Well, first, let me again add my thanks to the Hague Conference, to Christophe Bernasconi, and to the Department of Justice of Hong Kong SAR. I am really delighted to be here. It's a real honor and a pleasure. It was a long trip, but it was well worth it, and I hope I will return again. It's very difficult to be the last speaker right before the sort of end of a long day and this wonderful harbor trip. It's also difficult because there have been so many important things said from the start of Professor Bazado's comments all through the day, and I worry a bit that some of this might be repetitious. On the other hand, if I have things to say that other brilliant presenters have said, perhaps it makes me feel good. So let me start. The focus of the Hague Conference has been on private international law, which, as we have seen and as I think about it, is about rules on choice of law, international jurisdiction, recognition and enforcement of judgments, and related aspects of legal cooperation, which I think is part of private international law, but it's distinct from goals of unification or harmonization, which, at least to me, have been in the province of other international organizations such as UNCITRAL and UNIDROIT. I'm not going to say anything about the role of the United States specifically, except since I think I'm the only sort of formal U.S. speaker. We had a U.S. moderator. I think it's worth noting a few things that explain certain challenges for the United States as a participant in the Hague Conference. I realize this is not about the challenges to the United States. I will return to the challenges to the Hague Conference, but I think it's just worth noting this because I think it is reflective of a larger problem for The Hague. The U.S. is a federal system, and choice of law has been a matter for states in the United States. The American Law Institute, which has been referred to, has taken a substantial role in developing restatements on choice of law to try to bring some coherence to this generally incoherent system, in my view, in the United States. And some of you may know that there is work on a third restatement of choice of law. And so even within the United States, there's difficulty in arriving at consensus. And at the international level at The Hague, there is often resistance by just within the United States, states in areas where they believe that they should have competence. So it's a very complicated story for us. On questions of judicial jurisdiction, and I say that to David, sitting there with the potential experts group on jurisdiction, the options available to the U.S. are often limited by constitutional restrictions as to what it can agree to do. And finally, some of you know, there have been some difficulties with implementations of treaties that the United States has no difficulty with, but implementation of private law treaties in the United States presents its own federalism issues. And so I thought it was just worth a note about that. Of course, what we are talking about are the challenges to the Hague Conference. And I think the breadth of the Hague Conference provides one of its sort of immense opportunities, as we've heard, particularly with respect to different regions, at the same time, one of its biggest challenges. Differences in legal systems along with cultural diversity among all these countries makes consensus about even private international law norms difficult to reach. And we've had developed regimes like in the EU, which have already taken stances, and even in the United States, they have taken views about private international law that would be hard to displace with a worldwide instrument. Then there are projects emanating from other international organizations with an interest in cross-border issues that cover really related space, and they present potential problems of conflict and overlap. But I think the history of the Hague Conference that we've seen and has been discussed today, and its flexibility in the past, including its cooperation with other institutions, offer optimism for the future. Although the specific paths that it's taken do not necessarily predict the approaches it might take in the future. So I want to take, again, a brief look backward, and maybe this is a bit of a summary, in order to try to think about what guidance might be provided in the future. So the various Hague Conference projects in the early years, as we discussed, were conventions directed to the choice of applicable law. I'm not going to name them. Professor Bazzo did that. But not all of these conventions have had significant adoptions. But I do note, and again, this was mentioned, the conference has identified discrete areas where the need for predictability with respect to applicable law may be at its height. So the example that I would think of is the recent Hague Securities Convention, a small area, but a place where need was identified. And then there are other areas where the Hague Conference has directed its efforts away from formal choice of law rules, we've again talked about this, to methods of cooperation in both procedural as well as substantive areas. And so, again, this afternoon we talked about the success of the Hague Evidence and Service Conventions, which have achieved cooperation in these areas of procedure, and I emphasize what Dr. Bernasconi said about facilitating mechanisms for service of process and for obtaining evidence. That is, the introduction of a central authority in the foreign state to effectuate service under its own rules or to receive letters of request to aid in obtaining information for use in foreign proceedings under the Evidence Convention. And so that facilitation has been achieved. And then an even more activist variation of cooperation is found in the 1980 Hague Convention on the Civil Aspects of International Child Abduction. Because in addition to creating a judicial remedy to achieve the return of the child, the Abduction Convention has a structure of formal cooperation, which again includes a central authority to assist foreign applicants in locating children who were wrongfully removed or retained, to provide assistance to achieve return of the child through formal or informal means, and to provide information to achieve that result. And the 1993 Adoption Convention, again, established channels of communication between the sending and receiving countries to achieve cooperation between these countries and to assure substantive safeguards in inter-country adoption. And the 1996 Protection of Children Convention, which uses the framework of the harmonization of jurisdictional standards for child protection matters and then recognition of the ensuing judgments, the formal jurisdiction and judgments model, also has important provisions on cooperation and communication. So again, there's a designation of a central authority. Its obligations are quite general, and it's designed to permit delegation of responsibility to a variety of different local authorities upon whom the responsibilities under the convention are likely to fall. So there are the special provisions, I think they've been alluded to, on access rights, and the ability by a request by a state to obtain information or consider measures, or again, other methods of cooperation among contracting states that I think have been successful. And one can point to the 2007 Child Support Convention, again, where you have cross-border cooperation with respect to assistance in obtaining and enforcing child support orders. More traditional aspects, I guess, are represented by the ongoing Hague Judgments Project and the earlier 2005 Choice of Court Convention. On the other hand, the 2015 Choice of Law Principles used the model of soft law to endorse party autonomy in respect of applicable law, and it offered really a menu of a variety of options for countries to incorporate in their choice of law regimes for addressing party autonomy in commercial transactions. And the notion, and we've heard this today, that maybe one size doesn't fit all, and the Hague can be very helpful in thinking about the variety of options that might work in different countries or in different regions. The principles also indicated that they could have relevance in the context of arbitration, a topic to which I'll return in a minute. Other aspects of soft law have been embraced by the Hague Conference. The various guides to good practice, the 1980 and 1996 protection conventions have been influential in the operation of the convention, and they have been referenced in court decisions interpreting those conventions. So they have been really very, very important tools in the interpretation of those conventions. And on the technical side, we should not overlook the maintenance of the INCADAT case law database that is now available, I think, in English, French, and Spanish, and the development of the I-support system for the cross-border recovery of support under obligations under the Child Support Convention. We heard today about the Apostasy Convention and the e-app. So again, we see technology being used by the Hague Convention to support and even alter these conventions. One also sees the Hague Conference as sensitive to cutting-edge social issues. The experts group now on surrogacy, the one on cross-border recognition of settled or mediated agreements, and I suppose another area of inquiry is the possibility of work dealing with the recognition and enforcement of protection orders in the context of domestic and family violence. I think also about the set of relocation issues. I mean, maybe again, soft instruments are better. So that's my look backward, and now my look forward is to try to give some areas where the Hague might operate. I have to say, I don't think really quite as large as Professor Pocar. I'm a sort of small, incremental person. And so you'll have to move away from the giant idea to some small ones as I make my final remarks. In many fields, as I've sort of indicated, choice of law conventions may not be the appropriate path, but there still may be discrete areas where a multilateral convention on choice of law, the sort of traditional Hague method, may still be desirable. The Securities Convention is one that sort of came to mind to make me think about this. And in thinking of new areas, I have several possibilities in mind. One is suggested by the prior work in the principles on choice of law, which were addressed to both courts and arbitral tribunals in the narrow area of party autonomy. That was an initial step for the Hague Conference in the field of international arbitration, and one that could prove to be a good place for further activity. Arbitration has become more and more important and pervasive in cross-border disputes. But interestingly, international conventions in the field of international arbitration are silent as to choice of law. And private international law conventions don't necessarily reach arbitration. Neither arbitral statutes nor institutional rules overall provide much guidance. The UNCITRAL rules say, in the absence of designation by the parties, the arbitral tribunal shall apply the law which it determines to be appropriate. And the UNCITRAL model law refers to the law determined by the conflict of laws rules, which it considers applicable. And most arbitration statutes don't address the point at all. So the agreement about choice of law rules relating to the substance of law to be applied in arbitration in the absence of agreement by the parties seems to me to be a space that is open for further development, whether by a convention or by principles or in cooperation with other institutions. Another discrete area that might prove attractive for a choice of law convention is in the area of trade secrets. The choice of law decisions in various countries are all over the map. It's often unclear whether it's contract, tort, or property choice of law rules that should be looked to. And I know that registered rights, such as patents, copyrights, and trademarks, are likely to prove more controversial in trying to get final agreement about the applicable law. But trade secrets, again, it's a sort of small and discrete, narrow area, but it might be one in which to explore. The work of the Hague Conference also points, as I said before, to identifying areas in need of cooperative solutions. On the cutting edge, and this has been mentioned, is the topic of cross-border data, where the need for cooperation is imperative. My own limitations in the understanding of technology prevent me from saying anything more than noting this and saying a number of developments call for greater cooperation among countries. In Europe, the General Data Protection Regulation is about to go into effect, and the United States, maybe most of you don't know it, has recently passed the clarifying law overseas use of data act called the Cloud Act. So a possible practice guide on other potential soft law instruments is a potential area for development, and the Hague's ability to access information from governments worldwide to bring awareness of the development in this area is, I believe, a place for future work. One other area I think in need of attention, and this was raised by Professor Bazidow, is cross-border insolvency. The global principles for cooperation in international insolvency have been set forth in a project by the American Law Institute, but the possibility of further work by the Hague Conference would be desirable. Here, I stress the possibility, and I mentioned this, that the Hague might look for partners with other organizations to develop cross-border instruments. Often, earlier work has been undertaken or completed by other organizations or institutions, but the unique position of the Hague Conference as an intergovernmental organization offers the possibility of more pervasive international acceptance and the development of some kind of cross-border instruments. And I hope that that's a small little bit of work for the Hague Conference. Thank you very much.
A small little bit of work. Thank you, Linda.
Back to work.
With pleasure, with pleasure. Flexibility, cooperation, facilitation, processes, soft law, building blocks, post-convention services. All this reminded me of the fact that when I responded to Yuko's presentation, I was actually referring to two issues that came to my mind, but I only mentioned one, and that was the notion of consensus and how to interpret it and how to apply it. Your presentation made me realize that the other point that I had forgotten to mention, of course, is resources. If we are to embark on all these developments while at the same time trying to continue to make the organization a truly global, universal organization in Africa, in the Middle East, in parts of Central Asia, where still also Southeast Asia, where a lot of work remains to be done.
We have another 125 years.
Okay, okay. I think that for me the conclusion for all of that is, and you will have understood that that was actually the fundamentally underlying purpose of this whole exercise and the meeting here, is that for me the status quo is simply not an option. And we have to collectively engage really on a meaningful discussion with the members at the end of the day, of course, of this organization as to where do we go in the next 20, 25, taking it step by step, years with this organization.